Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Maritime Liens in Ghana. So this is the fifth part of the video with the same title. This video may be the last part of the video. If Ghana is minded to make the most capital of the maritime industry and maritime voyage in particular, it is my contention that it must permit the assignment or subrogation of maritime liens. This is because allowing assign and subrogation of maritime liens to step into the shoes of privileged claimants facilitates the efficient operations of a vessel and help to preserve other liens that would have been extinguished by the premature sale of the vessel to satisfy some higher-ranking liens. This is borne out by the practice in the maritime industry, where a lower lien holder pays off a higher lien holder who would otherwise have sold the vessel at a time when the proceeds of the sale would have been sufficient to settle only his claim, to the detriment of the other lien holders and claimants. Permitting a lower lien holder to pay off the higher lien holder and stepping into his shoes preserve the vessel to be sold at a later opportune time when the proceeds would be adequate to satisfy all the claims on the vessel. If Ghana is interested in encouraging persons and financiers of vessels in time of grave danger to the vessel, crew and goods, Parliament must amend the law to reflect current legal and maritime practice. Alternatively, a definite determination or pronouncement of the assignment or subrogation of maritime liens by the superior courts of the land is called for to settle or clear the current state of confusion. Secondly, setting this matter is of great importance to maritime industry players in Ghana, since the outcome plays a key role in the determination of priority of paying claims secure of the vessel. For example, if it is accepted that an insurer or indemnifier who pays a maritime lien steps into the shoes of the compensated, it means that the person has priority over the creditors such as mortgage. However, it is the position that an indemnifier of a maritime lien does not so step into the shoes of the compensated fellow, then it means that other creditors like mortgages have a priority, creating national maritime liens, making a case for towage freight liens. In addition to the traditional maritime liens provided under Section 66 of the GSA, the Liens Conventions gives contracting party states like Ghana the right to create national maritime liens, although national maritime liens would have the same characteristic as conventions liens. A shorter period of 6 months of 60 days after the sale of the vessel to a bona fide purchaser is provided for their extinction. This provision gives Ghana the right to create national maritime liens, which in its own assessment would facilitate maritime operations in the country. Admittedly, facilitate maritime operation in the country. Admittedly, embedded in the right to create national maritime liens is also the right not to create any. Ghana chose the latter, preferring not to create any national maritime lien. The wisdom is not exercising this right is not clear. However, it is my considered opinion that Parliament would have done the maritime industry in Ghana a lot of good if it had created a few national maritime liens that are essential to the operations of vessels, but essential service for which Parliament could usefully have created a national maritime liens is towage freight. Long ago, Dr. Lushington defined towage as the employment of one vessel to expedite the voyage of another, when nothing more is required than accelerating her progress. Usually, ships of all sizes, including those having their own means of propulsion, require the assistance of another vessel to be navigated safely, especially in port areas. This assistance may be required to enable a ship to make or leave a berth, dock, or canal, or to perform any makeover in confined areas. In fact, towage is compulsory in Ghana's two main harbors for vessels over 1,000 GT. The tugs tow arriving vessel at the harbor entrance and departing vessel along the berth. Towage services are crucial to the shipping industry because both vessels that are self-propelled and those that are not self-propelled carry on maritime activities such as navigation, fishing, and commerce. This clearly means that towage services are indispensable, particularly for non-self-propelled vessels like dam barges. At common law, towage freight gives rise a statutory right in rem, and it is not secured by a maritime lien. Technically, a statutory right only covers the tower right to pursue a particular judicial action to enforce payment of his freight as a debt. The drawback to this right is that it is defeated by the voluntary transfer of title and for sale of the vessel. This limitation puts the tower at a severe disadvantage, and manager release him in the distribution of the proceeds of the sale of vessel during a forced sale. It is common knowledge in admiralty practice that proceeds are often not adequate to pay for all liens, let alone an unsecured right to claim towage freight. Granting towage freight enables the tower to arrest the encumbered vessel and to conduct proceedings for relief against that vessel, without the necessity of locating the owner of the property. This remedial aspect of the right of considerable value in the field of maritime law, where the identified and location of the owner may be extremely difficult to ascertain, and opportunities for enforcing the claim rare and of extremely short duration. Furthermore, the existence of the liens has procedural consequences in that it secures a preference for the lien holder in the ranking of claims against a limited fund for the satisfaction of the debt of the property, and the preference for the maritime claimant a measure of security for the claim. This situation calls for concern because it constitutes unjust enrichment on the party of the ship owner for the tower services to be used in facilitating the voyage of vessel and to generate freight for the ship owner but not be paid. It can be argued that the tower can bring a personal actions against the tower to claim his unpaid freight. So this is the end of the article. Bye bye, and don't forget to watch my previous video. Bye.